Good evening, everyone. My name is Alexandra Sopolin. I serve as the newsletter editor and assistant secretary on the Queens Bench Bar Association board. I'm also a member of our Reproductive Rights and Legislative Committee. Queens Bench is so glad to see you all join us for tonight's MCLE presentation in our next era of the Fight for Reproductive Justice series. Before introducing our panelists, I would like to extend sincere thanks to the members of the Queens Bench Reproductive Rights and Diversity Committees for their hard work in organizing tonight's event. With special thanks to committee chairs Andrea Carlise, Sharon Alkire, Beth Hodis, Karine Cargo, as well as Kendra Rivas and Isha Vazirani. We are excited to hear from tonight's panel of experts. Since this MCLE is presented via Zoom, attendees' videos and mics will be muted throughout this event. You may submit questions in the chat, which will also include a link to the materials accompanying this MCLE shortly. Attendees who are interested in receiving MCLE credit will receive a link and code in the chat at the end of this event. You will need to complete the form to receive your MCLE certificate. An email will also be sent to registered attendees with a link to the survey after the event. With that said, I will now turn over to our moderator and fellow board member, Andrea Carlise.
Hi, everybody. Good evening. I'm Andrea Carlise. I am a board member of Queens Bench Bar Association. I am also a past president of California Women Lawyers and the National Conference of Women's Bar Associations. And I am happy to be here and to moderate this panel with our wonderful experts on the topic of reproductive rights and reproductive justice today. So we have so much to cover because, as I'm sure you all know, it has been a crazy, I guess, week and a half when it comes to abortion rights, and it's still going. So I'd like to first just thank our three panelists for all the effort they've put in the last week, and also to say, you know, we're sorry that we had to postpone, but we're glad that we're here tonight, and there's even more to cover. So we have with us tonight Jill Hirsch, who I'm just going to briefly tell you who they each are, and then when they start their part of the conversation, each of them will do a brief introduction of themselves as well. So Jill Hirsch is a partner at Hirsch Family Law Practice, and she will be addressing the impact of Dobbs v. Jackson Women's Health on reproductive rights and formation of the modern family in general tonight. And Ann Daniels, welcome Ann, is a reproductive rights advocate, and she'll be providing an update on the current legal landscape affecting reproductive health care in general, LGBTQ and trans rights, which I guess are included in there, and medication abortion access as well. She'll start us off on that. And then Terry or Teresa Johnson, who's a partner at Arnold and Porter and is also the president-elect of the Bar Association of San Francisco, will also be helping us delve into the medication abortion cases and all that's happening with that right now. And she'll also be talking about opportunities for Bay Area attorneys to fight for reproductive justice and updates on the work of the Legal Alliance for Reproductive Rights. So with no further ado, I'm going to turn this over to our first panelist, Jill Hirsch, who is going to talk about the broad range of implications from Dobbs and the resulting legislation for reproductive rights, including assisted reproduction and family formation. So, Jill.
Thank you, Andrea. Thank you, Andrea. If you see me looking up, it's because I have a large screen behind my little screen here. I apologize for that. I'm coming off of a cold, so bear with me. I want to start by saying that I think of our rights at this point as sort of shaped, forgive me for using male imagery, but like a football, where they were very small They've gone through a period of tremendous expansion, and they're now contracting down to a very potentially small space. For women and for gay and trans people in this country. And I think the contraction of rights is all interrelated. My career has sort of traversed the arc of the expansion of rights and the contraction of rights. But I want to start by talking about an image that was in the Washington Post last week. Washington Post had a political cartoon last week, and I think it says very well and best possibly where we are right now. It had a picture of Judge Kosmerek, who was the judge from Amarillo, Texas, and he was in his robe and he was ruling from a church pulpit. And if we read his decision and we look at the language, the zealots language in there, where he uses abortionists and chemical abortion and unborn babies and unborn children, I think the idea that he's ruling from the pulpit is really very apt. And it brings to mind in your resources an article I refer to, which is by Andrew Cockburn, which was in the Harper's Magazine in August of 2022, who described Ireland before choice was legal as a social theocracy. And I want to contrast that just as an introduction so we can hold these contrasts in our mind with language from Roe v. Wade, which said that the due process clause of the Constitution prevents invasion of the protected liberty, interest, and privacy, which includes the freedom of personal choice in matters of marriage and family life. Ordered liberty includes a fundamental right of privacy, broad enough to include a woman's decision whether or not to terminate a pregnancy. We have this vastly contrasting terrain here between the rational language used in the Roe decision and related decisions that I'll touch upon versus the irrational and theologically infused language used by Judge Kosmark, and also, as I will say, by Judge Alito or Justice Alito in the Dobbs decision. My thesis is that when a certain Christian theology or ideology displaces legal analysis and understanding the Constitution as a living document, that anything is possible because we become unmoored from both law and science. I want you to hold in your mind, if you can, the paradigmatic family, traditionally idealized, largely a fiction, but traditionally idealized as the unitary family headed by two heterosexual married people. This has been the paradigm against which the modern family, which is a term they use in England for contemporary families as we now know them, the modern family against which it has had to struggle for legitimacy and dignity and respect. My point is that the zeitgeist of the right is to corral women, limit the legitimacy and possibilities for the modern family, and return us to this imagined, fictionalized, halcyon days of that paradigm, which also implicitly is white and also implicitly is Christian. When I was in college, before Roe v. Wade was what came down. I was in college before abortion was legalized. And I remember, and we all knew, and we were privileged to know this, we all knew the workaround in order to get an abortion if it was needed. I went to Cal, and Cal Hospital was the place where abortions were provided if one could acquire an abortion. In order to do that, we had to appear before a board of 3 psychiatrists who were more likely than not to be all men. And we had to persuade them that we would go crazy, we'd lose our minds, possibly commit suicide. if we couldn't get an abortion. That was the workaround for privileged young women in order to get an abortion before abortion was legal in California and before Roe v. Wade. And here we are again, having to find workarounds to take care of women's health, if workarounds are even available. And in light of current laws, the exodus of maternal health care workers from non-choice states and the resulting closing of maternity hospitals. And as a Tennessee politician recently said, we will save every baby, we will save as many women as we can. I have practiced in family law for 45 years as both a trial and an appellate lawyer. And I practiced within that period of time. There was an arc of expanding rights and choices for the formation of modern families. And in the early 1990s, I started working with families that had same-sex parents because the public judge at that time was uncomfortable with the area. And so he would have me serve as a judge pro tem in the Superior Court. And I would have families appear before me that were either same-sex parents, or there would be two women on one side of the table and two men on the other side of the table. And he also referred same-sex parents to me for mediation of parentage and co-parenting issues. And how they became parents at that time largely was through assisted reproduction. That was also a workaround. It was done privately at home through the assistance of friends. The family code at that time did not cover the rights of children, really, who had parents that were the same gender. And the reason I put it that way is that the parents were deprived of rights, but the children were deprived in some instances of actually one of their parents as a result of the cracks in the system through which the parents could yank their children in a custody fight. I found workarounds through the appellate court guardianship proceedings. And more importantly, in the 2000s, I was presented with the opportunity of a woman who had used her ovum in her same-sex long-term intimate relationship with her partner, and her partner had used her uterus. In other words, the partner's uterus, it was my client's ovum, and they used IVF and they achieved a pregnancy of twins. And when the twins were 6 years old, the gestational mother took them away, refused to return them. We went to court with my client. And I always say civil rights work usually begins with a personal problem. And my client wasn't recognized as a person. The court said she had no standing and she had no parental rights. And we tried this case up through to the California Supreme Court. And what I tried to do, keeping that paradigmatic family idea in mind, was to saturate the court with the evidence of how truly ordinary this family was in every way, down to their Volvo and their home in Marin County, how truly ordinary they were, in order to be able to make a record for the Supreme Court, the appellate court, and then the Supreme Court, so that they could understand that this family fit within the paradigm that was so favored at that time. And also enabled me to argue the state's compelling state interest in finding two parents. And what we were seeking and what we achieved, among other things, was a finding that there could be two natural mothers and dual maternity in the absence of adoption. Again, we had to do a workaround. We had to figure out where the law needed to go. And I'm grateful to the trial judge, who I knew was going to rule against me, to let me make the record I needed to be able to make the argument I needed as we went up on appeal, where I was certain we would be going. While that was happening on a parallel track, there was the struggle for marriage equality happening simultaneously. And eventually, this led to the ultimate total revision of our family code to embrace all families and to enable family formation and gender neutrality. But it took years. And I feel like where we are heading back right now is to a place where, maybe not in California, but in other states, the recognition of the modern family is going to be on an ad hoc basis and it totally in jeopardy. While against the backdrop of what I'm talking about on the larger field of rights, in 1965, we had the Griswold decision, in which the court found that married couples had a substantive due process liberty right to privacy in their marriage and their family planning, and said that making birth control illegal was unconstitutional. In 1973, we had Roe v. Wade. In 2003, and I think this was a very important under-discussed decision, we had the Lawrence decision. And all of these, by the way, are cited in the resources that have been provided. And in that, the justices said that same-sex acts between consulting male adults in their home enjoyed the same substantive due process liberty interest in privacy. And the reason I think that was an important decision is because it was a decision coming from the Supreme Court that was lending legitimacy to the relationships of same-sex partners. In 2015, we had Obergefell. Again, there was a liberty interest in the right to marry that included same-sex couples. All of these decisions were based on legal analysis, nonpartisan, viewing the Constitution as a living and breathing document. All the while that those rights were expanding, again, imagining my imagery of a football, we had the religious right and the Federalist Society and dark money combining for their 40-year project of overturning Roe v. Wade. This has been a largely theological enterprise. There's a very interesting article cited in my materials called The Abortion Plot, which is in the London Review of Books. And one of the points that the author makes is that when Roe v. Wade was passed and the right to abortion was secured, that it left people in a position to start coming up with a different approach, which was morality-based. And if we read the decision in Dobbs and we read Kaczmaryk's decision, and this is why I thought the cartoon with the pulpit was so timely, what we see is really a morality argument going on. And it's only one group of people's version of what morality is, and it is a certain kind of Christian infused view of what morality is, including when life begins. It masquerades as a constitutional theory, which they call originalism, when it suits. This led to the Dobbs decision. The Dobbs decision relied upon, because the Dobbs decision said there's no legal basis for the right to an abortion, they resorted to what has been the traditional liberty interests that have been allowed and recognized. And they relied upon the alleged, and I use that word intentionally, alleged mores of the 1600s and the 1700s to talk about, in their irrational and vitriolic decision, why the right to abortion has never been enjoyed as a liberty interest. The information they relied upon, as this writer in The Abortion Plot will talk about, is superficial. They did a very superficial analysis. They didn't look beneath the information that they were relying upon. They didn't want to. Justice Roberts tried to persuade the majority to confine themselves to finding that the 15-week ban in the Dobbs case was was constitutional. But no, they took this as their opportunity to finish off that 40-year project and reverse Roe v. Wade entirely. And in doing that, they showed incredible disrespect for the principle of stare decisis, contrary to all of those justices' testimony at their hearings. And tremendous disrespect for the reasoning and the opinions of the earlier courts. But the Dobbs decision gave Clarence Thomas an opportunity in his concurrence to say very specifically that Griswold, Lawrence, and Obergefell and all substantive due process cases needed to be reexamined. They were erroneously decided. They were demonstrably erroneous, which leads us right into Kaczmarek's decision, which is really closing the circle with this, which uses the language of these theologically infused anti-abortion right with unborn babies, abortionists, chemical abortion. My co-panelists will talk about this more than I will here, but the reliance on the Comstock Act is very telling, because the Comstock Act of 1873, which is also cited in the materials that I have provided, the full name of that alone tells us everything we need to know: an act for the suppression of trade in and circulation of obscene literature and articles of immoral use. Earlier in the 20th century, birth control was removed from the Comstock Act. Patch Schroeder, I don't know how many people here remember her, in the mid-90s tried to get Congress to remove the word abortion, and they declined to do that. And it is still on the books as a federal crime to disseminate materials suggesting, recommending, or referring to, or explaining how to get an abortion. And Kaczmarek relied upon this as his leading argument in the opinion that he wrote. And I think there's going to be a trend of people utilizing this statute going forward. The Dobbs decision led to the congressional bill, which is called the Respect for Marriage Act of 2022, not to be confused with the right to marry in every state. I think what when Obergefell was cast in jeopardy by Clarence Thomas, Congress, anticipating there could be a problem, passed the Respect for Marriage Act, reversed DOMA. But the other thing that it did is it gave full faith and credit to any marriage that was performed in another state where it was legal. But it did not guarantee the right to marriage to same-sex people in every state. The Dobbs decision also enabled states on a state-by-state basis to make any, basically any laws on abortion that they wanted to. In my materials, I also refer you to Jessica Valenti, who has a column called Abortion Every Day. And every single day, she sends an email that explains what's happening in every state in the union, which is not the same, but contains tremendous amount of information that is very telling in terms of trends. Most of this, there are many states in the country now that have no exceptions for rape or incest. The most interesting of these, I think, is Mississippi, because we can all try to figure out why this is the case and what this discussion looked like. Mississippi allows an exception for rape by a stranger, but does not allow an exception for rape by a family member. And of course, what that does is takes children and places them in a forced birth environment. Jessica Valenti would say that all of these exceptions are fake. That's her word, that they create an illusion of being sensible, but none of them actually works, because the infrastructure of trying to effectuate or achieve this exception is so contraindicated by psychology and sociology around abuse and sexual abuse and rape. And because the doctors are so immobilized because of all the different laws, that the exceptions themselves are actually, in effect, useless. Dobbs also allowed states to make rules that life begins at fertilization. And if life begins at fertilization, then what that means is that if you combine that with the jeopardy that Griswold was cast in as a result of the Dobbs concurrence, means that we could find that IUDs are going to become illegal, because in theory, what they do is they create a hostile environment to the implantation of a fertilized egg, and that the morning after pill could become illegal. Now, in Iowa, they're already chipping away at birth control. In Iowa, they're depriving rape victims. The state used to give them the morning after pill. They are now no longer giving them the morning after pill. They also don't allow for abortions. So Iowa is becoming a forced birth state. And many, according to Jessica Valente, many of the victims of rape are children. And so we find ourselves in a forced birth environment for children. If there is no, if life begins at fertilization and you can't abort a life, then that means that we will eventually see a challenge to IVF. IVF has long been opposed by the evangelical Christian and Catholic organizations. IVF requires the retention, the freezing essentially of an embryo, a fertilized egg. And if there can be no IVF, which I believe is down the road for us, and I don't think there's anything to tell us in the majority here that would prevent a state from eliminating these rights. I mean, Michigan, for example, surrogacy is illegal, it's a crime. And I don't think anybody's going to tell Michigan they have to allow surrogacy. So I think by the same token, if a state is not going to allow IVF, I don't foresee any centralized authority telling them that they have to do it. But if there can be no IVF, there could be no surrogacy. And if there can be no IVF, there can be no, consequently, same-sex male couples that can have biological children, or single men or single women who can have biological children, or for that matter, two women in a relationship who would like to combine their biology and have a biological child. Those options would be eliminated for them, and I don't imagine that there's any centralized court that's going to say they're entitled to have that right. As a caveat for the lawyers in the audience, anybody who works with surrogates, you need to advise either the people that are using the surrogates or the surrogates themselves that they need to receive all medical care in a choice state. Because if there's something wrong, if there's maternal health issues, they're not going to be able to get the help they need in a non-choice state. All embryos for IVF should be retained in a choice state. They're cryogenically, probably not exactly the right word, but they are cryo retained. They should be kept in a choice state, because the risk of not being able to dispose of them, by the way, all fertilized eggs in IVF go through genetic testing. And the ones that fail the genetic testing are not considered viable for transfers into a human body. And so if you're in a state that down the road is going to start attacking the ability to dispose of embryos as a result of IVF, they need to be retained in a choice state as well. With the jeopardy of Obergefell as a result of Dobbs, it raises the question about second parent adoptions, raises the question about foster parenting and presumed parentage status from marriage. There's the English, I keep referring to the English because I started talking about this first in England. It's what they call the knock-on effect. The knock-on effect, if you think of it as a bunch of dominoes, what falls down the way as a result? As the result of Dobbs, in Idaho, they're now criminalizing travel across state lines. This is something that we could not have imagined, but they have criminalized taking a child. It could be a 10-year-old who is raped across a state line to get an abortion is now prosecuted as abortion trafficking, and it's a criminal act. In South Carolina, 21 legislators signed on to the idea that women should receive the death penalty for having an abortion. 9 of them withdrew their consent to that, I think because of the public backlash. But the fact that those words can come out of my mouth The fact that the idea could even be said out loud, even between 21 people in South Carolina, is shocking. It should be shocking. In Texas and other states that have vigilante laws to enforce their anti-abortion rules, we now have a new way for men to control and isolate and abuse women. And a good example of that is the lawsuit being brought by that man against 3 women friends of his former wife because of text messages helping her to get mifepristone. States allowing abortion based upon the health or life of the mother have varying exceptions. The problem with all of them, the problem with all of the alleged exceptions, is that they're so mushy, they're so hard for the doctors to understand. And also many of them are only available as affirmative defenses in the event of criminal prosecution. These doctors are afraid of losing their licenses. They're afraid of being liable for attorney's fees. They're afraid of civil liability, that they become immobilized so that women are not getting the help they need. I mean, we are not hearing about mifepristone and the fact that it's used for miscarriages. If Kosmark's ruling is allowed to stand, what happens to the women who are going through miscarriages? But then on the other hand, what happens to the doctors who assist a woman going through a miscarriage under any of these scenarios, or an ectopic pregnancy, or any of the other, or babies without brains? We are being corralled, women are being corralled into forced birth and potentially death and permanent injury environments. Margaret Atwood, again, Margaret Atwood is referred to in the materials that I have, wrote in an opinion piece in the Atlantic Monthly saying, I invented Gilead and the Supreme Court is making it real. And I think that what we find is that this sort of concerted attempt, this is where my football gets small at the other end. I'm almost done here. The concerted attempt to restore this idea forcibly and involuntarily, restore this idea of the old Christian infused, idealized, never really existed for most people, paradigmatic family unit is absolutely at play here. And I just want to close by quoting a couple of people. J.D. Vance said during his campaign for the Senate that the sexual revolution has been a disservice because now people, read that as women, leave unhappy or violent marriages instead of staying for the children. And a political operative named Miss Park, who's a Republican, said, the sexual revolution has discouraged women from controlling themselves sexually, thus reducing marriage and childbearing. So reproductive rights isn't only about abortion. It's about the choice to not be pregnant, choice to be pregnant, the choice to use assisted reproduction to form a modern family, a choice to be able to pursue your own form of happiness in whatever form that takes. And all of this is combining to try to deprive us of those rights. And at this point, I'm going to hand this off to my co-panelist, who's going to seg into a discussion of both mifepristone and LGBTQ rights.
Thank you so much, Jill. That was so much to think about, and it's just such a scary landscape that we're muddling through right now. But it gives me hope to know that we have all these brilliant minds to help us do it. And I'm going to hand it over to another brilliant mind, Ann Daniels, who is going to start with the topic of how Dobbs is affecting transgender rights. So Ann, go ahead.
Thank you, Andrea, and thank you, Jill, also. I like to introduce myself by saying that I am a recovering attorney. I have not practiced law for over 25 years, but I have been a reproductive rights advocate for over 40 years. including a stint as the director of the Northern California branch of what is now NARAL Pro-Choice California. So I'm just going to dive right in, because when we were first discussing this panel, I thought it would be a really great idea to talk both about LGBTQ rights and mifepristone. What was I thinking that I could combine those both together in a reasonable amount of time? So I'm going to sort of barrel through and talk fast. I'm from New York. I apologize in advance. So first of all, why LGBTQ plus rights and mifepristone? Because those may seem like kind of apples and oranges. What I want to stress is they're not. They are both based in the same swamp, which is requiring people to conform to exactly what Jill was talking about: conservative, religiously based ideas of gender roles and activities, and specifically to perform certain gender roles in the way that the Christian religious right wants. Boys must be boys, girls must be girls, pregnant people must have babies. You don't get a choice. So, LGBTQ plus rights. The ACLU is currently tracking 435 of these bills. That's what it was a couple of weeks ago. It might even be more now. There were hundreds of these before the Dobbs decision. The numbers are increasing now because of the Dobbs decision. The range of these bills includes religious exemption laws, which originally had to do with gay marriage, but they are moving from same-sex marriage to attacking trans rights and especially healthcare. Laws about healthcare. At least 20 states have introduced legislation outlawing gender-affirming medical care for young people and or penalizing parents and healthcare providers who allow it. So that's sometimes criminalizing gender-affirming, gender-appropriate healthcare, especially for kids, preventing new treatment, and forcing people who are currently in transition to detransition by withholding treatment. Just let that sit with you for a minute, what that actually means to people involved in this. It is life-destroying. Other laws, modifying medical malpractice law to increase liabilities for doctors who provide care for trans use. Preventing telehealth delivery and insurance coverage for gender-affirming care. And there's more. I'm just sort of hitting I was going to say high points, but low points. Sports bans. Some good news there, actually. The federal government has proposed a rule protecting trans athletes, and the Supreme Court, amazingly, recently ruled 7-2 without an opinion that they would not dissolve an injunction against an anti-trans West Virginia law pending appeal. In case all the negatives in there got to be too much, this is good news. They're keeping the injunction against this law. Education, in addition to sports bans, banning discussion, even discussion of pronouns or gender identity in schools. Book bans, banning DEI curricula, other forms of free speech and expression, penalizing teachers who do not take action against kids who they may even suspect to be showing trans behavior. Bathroom bills, everybody's favorite. I'm not going to go into that. Anti-drag bills, performance bans, doing away with ordinances, including gender and gender expression in anti-discrimination laws in policies, just carving that right out. Prohibiting people from being able to change their gender identifiers on their IDs and government documents. So if your driver's license says that you are a girl, and you cannot change what that says. I want to take just a minute to talk about the effects of all this on BIPOC people and communities. First of all, Black trans women have always been the most at risk. The violence and murder rates for Black trans women in any decent society would be absolutely insupportable. Trans bans are based on requiring conformity to, again, this is what Jill was talking about, the religious right, white American ideals of gender and of gender expression. But in many other societies and cultures, people dress differently. People express themselves differently. People do different things. BIPOC folks literally may not be able to safely live up to Western white ideals of expression, of dress, of behavior. One size does not fit all. So I'm going to circle back at the end to what the federal and California state governments are doing about all of this anti-trans legislation, because there is some good news. And pivot now to talking about medication abortion. The Texas case, Alliance for Hippocratic Medicine versus the FDA. It's real brief on the status. The district court decision on Friday, the 7th, issued a stay of the FDA's approval of mifepristone. That decision goes back 25 years, but the court stayed that approval. It's the first time a court has tried to overrule the FDA. Even Lindsey Graham does not like that. The Fifth Circuit overturned the stay, but only in part. The Supreme Court issued a complete stay of the district court decision. That goes until midnight tomorrow. Briefs were due today. Tune in, we'll have more news next week. The case was filed by the Alliance Defending Freedom. They wrote the Mississippi law that was upheld in Dobbs. And by the way, the Southern Poverty Law Center calls them a hate group for their work against LGBTQ folk. Again, the fight against LGBTQ plus rights and reproductive rights is the same fight. So it absolutely reads like a forced birth polemic. Not surprising, given Judge Kaczmarek's background as avowed anti-choice, anti-separation of church and state, pro-religious right, anti-LGBTQ, all that stuff. Right from the start, the decision calls abortion killing the unborn human. It says mifepristone starves the unborn human to death. I'm not making this up. I could not make this up. This is in the opinion. He literally says that pro-choice forces like Planned Parenthood are eugenicists and Übermensches. That's Nazis. Highlights, I don't really want to go into the legal part of it very much because I am not an administrative law, never was an administrative law practitioner, but I do want to focus on the standing issue. Judge Kaczmarek ruled that anti-choice doctors associations have standing because of harm to doctors from abortion and the, quote, drain on the organization's resources from counteracting the defendant's actions. In other words, the anti-choice groups had to take time and money away from anti-choice forced birth propaganda in order to deal with the fact that women are having abortions. And this gave them standing. This could potentially give standing to any anti-choice organization for anything, as far as I can tell. Preliminary injunction, likelihood of success. Yeah, the Zombie Comstock Act. And Kaczmarek goes on at huge length about how dangerous mifepristone is. Total bad science. The studies that the plaintiffs and the court relied on don't even show serious harm. They do show that women undergo bleeding and cramping. They're having a miscarriage. That's medicine. Only one of the studies that they cite even looks at serious complications within the time period that mifepristone is used in the United States. And it says the drug is safe and that serious complications are rare. Kaczmarek says studies show chemical abortion causes great physical and intense psychological trauma and post-traumatic stress. That's a quote. The vast majority of the studies show exactly the opposite. He claims that mifepristone is more dangerous than surgical abortion. Let's do the numbers. Serious complication rates, 0.16% for surgical abortion, 0.31% for medication abortion. That is less than 1/3 of a percent. Compare that to 1.4% for childbirth and much, much higher in communities of color. There's more, but basically he just rattles off these truths that we know to be self-evident that are just completely bogus. I want to turn for just a moment to the case in the state of Washington called State of Washington versus the FDA. This one challenges 2023 restrictions that were placed on mifepristone providers, including a requirement that they be pharmacy certified. So this one seeks to uphold the availability of mifepristone and to take off the restrictions. The decision came down 1 hour after the Texas case with the opposite result. A preliminary injunction preventing the FDA from changing availability of mifepristone, but only in the 17 states and the District of Columbia, which were parties to the suit. No nationwide injunction on that one. And just to say, in case you're wondering about overruling the FDA, there are a couple of cases challenging state laws restricting the use of abortion medication on basis of the supremacy clause. So yeah, that is out there. Terry is going to go into what could happen if the Texas case is upheld, and some additional legislation. So I'm gonna pass that one for right now. But I do want to talk about the ripple effects of a ban on mifepristone on reproductive health care. Obviously, it makes abortion harder, more expensive, less accessible. That's its whole purpose. Medication abortion accounts for more than half of all abortions in the United States, even more since Dobbs. It's the only reasonable access for millions of American women, and it's key even in states that are protective of reproductive rights. 45% of American women live in a county with no abortion provider. In several states, that number rises to 2/3. It would be even worse if medication abortion were banned. 14 states have no abortion providers at all. Providers that offer only medication abortion using mifepristone may not be able to switch to offering procedural abortions. So banning mifepristone basically can remove the few providers that exist in some places. Again, not an accident. That's the whole point. Again, a really disproportionate impact on communities of color. Costs, systemic racism that affects employment, insurance, childcare, the ability to take time off, which of course is much worse in states with waiting periods where pregnant people have to go back to the clinic repeatedly. Looking briefly at the effects on other reproductive health care, Jill has touched on some of this, but there are verified reports of women of reproductive age being denied prescription medication at pharmacies. This includes medication used to treat stomach ulcers, lupus, arthritis, and cancer, because the pharmacists are afraid that some of these medications could be used in medication abortion, could be used to terminate a pregnancy. They're afraid of prosecution. This leads to what I call the Walgreens effect. Walgreens decided that they were not going to provide mifepristone in states where abortion was illegal, but no worries. They're going to provide it in the rest of the country. And they're trying to pass themselves off as being very pro-choice because of this. Jill mentioned that mifepristone is used in aiding people undergoing miscarriages. It's also used for people who have ectopic pregnancies. Ironically, the Kaczmarek decision rests heavily on the FDA not including certain requirements for prescribing mifepristone, including an ultrasound. Why? Because Kaczmarek says ultrasound can diagnose ectopic pregnancies, and we want to protect these women who have ectopic pregnancies. But of course, women with ectopic pregnancies are being denied care until they are at an absolute critical point in hospitals. They're just literally sitting there waiting to go into shock or have a rupture. So what are the federal and California states, California state government doing about all of this? both medication abortion and attacks on trans rights. Keeping an eye on the time. I don't think I have time to go into details, but sort of a summary of it.
You have
The
like 5
Biden
minutes.
administration has expressed opposition to anti-choice and anti-trans efforts, rolling back some of the Trump administration leads, mostly executive orders and rulemaking because Congress. Specific actions to protect communities of color with respect to reproductive health. They're thinking about it broadly. They're thinking about it inclusively. The executive orders and the rulemaking don't involve just the FDA or Health and Human Services, which you'd expect. They also involve Homeland Security, the Federal Communications Commission, Education Department. The administration is meeting with governors, with state legislators, with reproductive rights groups. They are trying to think as broadly as possible. The lesson I want to give here is we need to be doing this because as the Texas bounty law and other laws have shown, the no crossing state lines laws, the forced birth proponents are thinking really broadly and really creatively. And if we don't do the same thing, then we are always going to be putting out yesterday's fire. And we're not going to do it. There will be too many fires. We need to be proactive in the broadest, most creative possible way. California, we're here. California has declared itself a sanctuary state for people, both people needing reproductive health care and for trans folk and their families, especially those needing health care. There are literally dozens of proactive laws from many different approaches, from law enforcement to a whole variety of ways of dealing with healthcare, social services, education, information dissemination. Again, broad, inclusive thinking. Do I have time to go into a little bit of detail, or should we hold this for questions if there are any?
You have a few minutes if you want to go into a little detail. You can, we have like 3 or 4 minutes.
Okay, so talking first about abortion, since the Dobbs and Texas rulings, it's the Department of Justice, of course, that has appealed the Texas ruling. The Biden administration has done a number of things, including a task force on reproductive health care access. The last meeting was just a couple days ago. Selected actions, there is now reproductiverights.gov public awareness website, strengthening HIPAA and consumer privacy rights, guidance to schools and individuals, guidance to pharmacists that they cannot deny on the basis of sex, referral services hotline for Title X family planning patients. Specifically with respect to communities of color, efforts to address disparities in maternal mortality, called the Data Mapping to Save Moms' Lives Act. I have no idea why. It doesn't even have a good acronym, but it includes new funding for this in the 2024 budget, which is very important. The money's got to be there. Plan to expand ACA coverage to Dreamers, to DACA recipients. Biden wants Congress to pass national legislation legalizing abortion, basically to codify Roe versus Wade. Personally, I don't think codifying Roe versus Wade is good enough. I don't think anything's going to happen with this Congress, but it's very important that this demand is out there, that Congress do that. California, a whole lot of things, including, but not limited to, in no particular order. As I said, California has declared itself a sanctuary state. Governor Newsom is stockpiling misoprostol. The right to abortion and contraception, of course, was enshrined in the California Constitution in last November's election. The Protecting Reproductive Freedom Act basically is to make sure that nobody in California is investigated or prosecuted or incarcerated for experiencing a pregnancy loss. And it creates a private civil right of action for people who have their rights violated. A law that prevents the Medical Board of California from punishing doctors for providing abortion care. Bans on releasing medical information This has a lot to do with people who come to California to get reproductive health care, or who are being persecuted by the governments of other states. The California Reproductive Health Equity Program gives grants to providers who offer uncompensated reproductive health care services, and NPs and midwives can perform first trimester abortions without a physician. That's just skimming the top. On LGBTQ rights, Biden is by far the most supportive president. That includes Obama. Let's not forget it's Biden who brought Obama to supporting same-sex marriage. A lot of the orders have yet to be implemented, but executive orders and rulemaking. Support for the Equality Act, which Congress is not going to pass right now, but let's see, what else can I do real fast here? Biden's first day in office, an executive order directing all federal agencies that enforce laws prohibiting sex discrimination, requiring them to also prohibit discrimination based on sexual orientation or gender identity. That applies to employment, housing, healthcare, education, credit. Promoting an executive order promoting racial equity and directing federal agencies to eliminate systemic barriers to care for underserved communities, including both communities of color and LGBTQ people, among others. Ending the trans ban in the military, establishing the Gender Policy Council, direction to support LGBTQ refugees and asylum seekers, not yet implemented. Stay tuned. Trans prisoners' rights, a proposed rule that schools getting federal money can't outright ban trans kids in sports. That one, no outright ban, but they can use more nuanced methods. So honestly, it's not as great as it could be. Other efforts to eliminate discrimination in schools receiving federal funds. However, once again, administrative rules, the DEA proposal as of February would roll back COVID-19 telemed rules. These rules allowed prescribers to prescribe long-term drugs to patients without seeing them first. This is meant to combat the opioid crisis, but telemedicine may in fact be the only way that some trans folk can get care safely. That rule, by the way, is effective as of May 6th with a 6-month grace period. California, again, sanctuary state, protecting families that come here for medical treatment, protecting families who move here to avoid consequences of treatment they got in their previous home state, preventing healthcare providers from releasing medical information. And I love this one. It makes any potential out-of-state arrest warrant for violating laws related to trans medical care, quote, the lowest law enforcement priority. You can't tell them to forget about it, but that's as close as it comes. California allows you to change your gender ID marker on official documents without a court order. That's really, really important. Family leave provisions apply to LGBTQ families. Agencies placing foster children can't deny LGBTQ families. The Transgender Wellness and Equity Fund and Inclusive Care Act, my God, these names, for trans inclusive health care. On the other hand, California does have its very own anti-trans bill. This would require a school to notify parents if they notice a child identifying with or taking actions not consistent with their assigned sex at birth. And why? Because it's going to provide trust between parents and schools. It's before the Assembly Education Committee. It's not going to pass, but just the fact that it was even introduced means that we are constantly needing to be vigilant. Basically, California is a good place to be right now. The Biden administration is doing more than any before, but for individuals, trans individuals, individuals needing reproductive health care, abortion of any kind, it is still dangerous and scary out there. So on that cheerful note, I am going to pass this over to Terry to talk about what we can do to help and to talk about the decisions.
Thanks so much, Anne. We really appreciate all that you did to get all that information into a 25-minute little block, and very impressive. Thanks so much. So Anne, without further ado, because we want to get everything you have to say out there as well, I'm going to turn it over to you to tell us more about the mifepristone cases in Texas and Washington and what's going to happen from here.
Sure. And hi, everyone. I'm Terry Johnson. I'm a corporate partner at Arnold & Porter. And as Andrea was kind enough to mention, I'm one of the co-founders of the Legal Alliance for Reproductive Rights, which is an organization that was formed by the Bar Association of San Francisco and by the San Francisco City Attorney and a group of law firms, now about over 70, that are dedicated to providing pro bono legal assistance to providers, to patients, to supporters, basically anyone who requires help in connection with the exercise of reproductive rights. And I'll talk a little bit more about law at the end of this. But to sort of pick up with respect to the Texas decision, I wanted to just note a couple of things. As you can tell from this discussion that we've had, and kudos to Jill and Anne, my co-panelists, for laying the landscape and setting the tone. And I think at this point we're all very keenly aware of the fact that the Dobbs decision, despite being portrayed as having a clarifying effect on the reproductive rights landscape by deferring to states, has actually really only made things more contradictory and more complicated, and with dangerous effects, I think, for pregnant people and for their supporters. So just to touch on what happens if tomorrow night SCOTUS allows the Fifth Circuit decision to go into effect, that pretty much takes us back in time to the year 2000 in terms of approved uses of mifepristone. And so what that means is it can only be used up to 50 days of gestational age. It's got to be dispensed in person. So that's a significant thing. No mailing it. It's got to be dispensed, administered by or under the supervision of a qualified physician. So again, that changes things significantly in terms of who can dispense it. Very limited in terms of that. So no sending it out via the internet, no having pharmacists dispense it, got to go to a clinic. So these are, big changes to the method of dispensation. On top of that, state law in whatever state you happen to be in will affect the use of MIFI as well. And that would apply whether it's being used for the purpose of abortions or, as Anne was noting, for the purpose of treating miscarriages. So this applies to mifepristone used in whatever way and for whatever purpose. It's also worth noting that the location matters because, as Anne was noting, there's the Washington state decision that came out on the same day as the Kazmarek decision, which effectively reached the opposite result, and where the court ordered the FDA not to further restrict the use of mifepristone in those 17 states and in DC. So it kind of appears that the MIFI use can continue in those 17 states as it was before April 7th. Notably, California and New York are not a part of that group, but kind of, really where this leaves people is in a between a rock and a hard place in terms of compliance. It's very murky. There are questions about whether generic mifepristone may be used because that was approved after the year 2000, or whether only brand name mifepristone can be used. Also, the current labeling of the product is different from the way it was in the year 2000, and that creates questions about whether and to what extent the drug can be used for, out of risk that it would be in violation of the labeling requirements. So there's just a boatload of difficult questions that providers and patients are going to have to navigate, and inevitably it's the pregnant people who are going to be harmed. As Anne noted, one of the key legal issues at play here in the case relates to standing, whether the plaintiffs group of anti-abortion doctors really have standing to sue. It's not at all clear as to whether how they have been harmed specifically, and and I think it's also notable to think about the ripple effects of that, and also the potential ripple effects of a decision by a court in an area that has heretofore been occupied by an agency. So we have a federal court, which is not, judges are not scientists, generally speaking, stepping in to sort of second guess what the FDA has decided from years of scientific research. And so imagine the ripple effects of this that you could see that could have implications for a whole host of other agencies. And I think that's a significant risk associated with this. And I hope that as SCOTUS thinks about this, as they are probably thinking even as we speak, that they are considering those implications and hopefully considering that they will decide that the Fifth Circuit decision and Kaczmarek's decision should not stand. Turning back a bit to the practical side, as Anne noted, one of the tiny bits of good news, which isn't really, we wouldn't otherwise in any other world think of as good, is that medication abortions can be undertaken using only the second drug, using only misoprostol, which has long been approved by the FDA, and for a variety of different things, not just medication abortion or kind of miscarriages. So the ability to challenge that approval would be significantly more difficult. And states like California and New York have been stockpiling misoprostol, anticipating that they may need twice as much of that going forward if that's kind of where we end up going. But I think it's notable that just generally speaking, as we've kind of alluded to in this discussion, the Kaczmarek decision is really an example of some of the one of the radical anti-abortion positions that we're seeing get promulgated in state legislatures and in courts all around the country. And this kind of segues a bit into in some of the things that we've talked about around the country. Jill, you mentioned a number of them, and you mentioned a number of them. I think I wanted to mention another thing that's kind of sneaky, but came out and was taken away. But I think it's illustrative of one of the other things that is in the playbook, that the Idaho Attorney General put out a legal opinion, which he shortly thereafter rescinded after Planned Parenthood brought a lawsuit. And in the legal opinion, he said that doctors and other providers would be prohibited from making out-of-state referrals for patients seeking abortions. So that would mean even apply to something like, here's a pamphlet, here's the website. That would have been deemed to be not only a potential criminal offense, but also would put their healthcare licenses at risk. So. And as we know, one of the things that's a big issue for doctors is that they may be licensed in multiple states. And in many states, the way it works is that if you lose your license in one of the states, that automatically takes away your license in the other states, regardless of whether what you did was a crime there. So some states like California are trying to pass laws to provide protections against that. But it's not hard to understand why doctors are concerned and acting conservatively in playing all of this out. But broadly speaking, and then the rule that says the new law signed into law in Idaho that Jill, you were describing, that bans and essentially puts liability on people who assist minors in traveling for abortions without parental consent. We're just seeing more and more of these kind of unprecedented attempts to apply state law in an extraterritorial way. And again, it comes back to this notion of the complexity of the landscape that's starting to arise. In Texas too, another one crazy. Jill, you mentioned this case as well about the Texas man who's suing his wife's friends who assisted her in obtaining the abortion. I think it's worth underscoring that he actually brought that suit under the state's wrongful death statute. His lawyer in that matter is the author of SB 8, the Texas Bounty Hunter Law. So obviously he was totally familiar with that, could have chosen to do that, but no, picked the wrongful death statute. And I think that triggers obviously potentially greater penalties. And it's based on the idea that abortion is murder under state law. So it's coming back to this notion of heightened criminalization of the exercise of reproductive justice, which is just shows us, how crazy the current climate is. So it leaves us, I think, kind of all wondering how we can help, what we can do to help. And The example that I can speak to sort of most particularly is the Legal Alliance for Reproductive Rights. As I said, it's an organization of a large number of law firms. We started out of San Francisco. We have law firms of a variety of sizes, big national firms on down to small boutique firms, solo practitioners, criminal defense boutiques, for example, because we have seen a range of different types of things. There have been opportunities for folks in, all sort of spectrums of the legal landscape to be involved. We've done a range of research projects for abortion clinics, for reproductive rights organizations. We've done things where on the criminal side, representing protesters who have been arrested at protests. It really has run the gamut. And I think it's worth noting too that the range of issues that have come up, as we've kind of alluded to in this discussion, is broader than just somebody going to a clinic or trying to get abortion pills to have an abortion. It can impact the treatment of miscarriages. It can impact the treatment of ectopic pregnancies. It can impact reproductive, IVF or other ways of exercising your rights to reproduce. I mean, it's not just unwanted pregnancies, it's wanted pregnancies, it's a lot of different things. And so what I would say generally is that, and this I think has been true for some of the national organizations as well, which I'll touch on, there hasn't been an enormous avalanche of cases. It's not like we've seen a lot of real kind of litigation come down the pike. Most of it has been advice, counseling, and I think a lot of that is that just because, as we've talked about, the landscape is really murky. It really is very unclear to see exactly what you can do. It depends so much on where you are, exactly what you're doing, who you're treating, who you're helping, are they traveling? It's quite a morass. And so at this point, and things are changing all the time, as we've seen just in the snapshot of the mifepristone case, where over the space of a week and a half, it's gone from the Texas District Court to the Fifth Circuit to SCOTUS. Who knows where it may go back down? It may stay there. We'll see. And that's just one. It's just one case. So the landscape is so treacherous and so difficult to navigate that I think that's most of the job has been to look at that. There is another organization that exists to support that's sort of similar to the to LAR, called the Abortion Defense Network, and LAR has a website. The Abortion Defense Network also has a website. It was formed by a group of the leading reproductive freedom nonprofits, like the Center for Reproductive Rights, the Learn Project, the ACLU, and those organizations then identified law firms that had done a lot of nonprofit or a lot of pro bono work with them on reproductive justice matters, and asked them to be part of the network. And I think part of the idea there was, and this is obviously really important, to try to have a coherent, unified approach to these matters. As we all know, we're all smart lawyers. We can think of different ways to argue about a particular point, and given it's helpful to have the national organizations looking at what at trying to think about what the most effective approach would be for arguing these cases, so that you're not taking a position that's then going to come back and bite you down the road. So within the Abortion Defense Network, then it provides resources for people who are providers, provides resources for people who are patients, also provides criminal support if folks are in that position too. So it too is a great resource. There is and if folks are interested in being involved in any of these efforts, in particular in the Legal Alliance for Reproductive Rights, please feel free to drop me an email and I can get you guys involved. There are some other growing efforts as well to kind of create ways of sharing information about this, because one of the things that's really so valuable in working on these areas, considering how murky the landscape is by being able to draw on the advice and experience of others who have looked at these issues as we've trying to figure out, how to advise somebody, trying to figure out whether they can, prescribe mifepristone in Arizona, for example. So I wanted to touch just briefly on a couple of things about California. As we've talked about, as Anne described, California is an access state where the right to obtain an abortion is well protected. And a question that has come up, I think, for those of us working in this space is, are we at risk? Are we California lawyers at risk for advising people in banned states? And that's a real question for a number of lawyers. We're all probably familiar with the situation that went on that a group of conservative legislators in Texas called the Texas Freedom Caucus went after the law firm of Sidley Austin, which is headquartered now in Texas, and sent them a threatening letter last year, basically saying if they were going to be using their firm's resources to support people from the firm traveling to seek reproductive freedom care, that they would be at risk of losing their law licenses. Now, I don't think they ever followed through on this. I'm not sure that there were others that other firms that really got these kinds of threats, but it's an indication of the sort of lengths to which, and unfortunately the kind of creativity that we're seeing on the anti-abortion side of things. And so in California, for example, it's conceivable that banned states could try to challenge bar licenses. There was recently a state bar rule that requires attorneys to report misconduct by other attorneys. And one of the things that folks involved in this abortion defense area worked to do and were successful in doing is in adding a carve out to that new state bar rule that exempts you if you are advising clients on matters that are legal in California but not in other states. And I think to me that's kind of a good indication of the sorts of things that you just don't think of as being a ripple effect from a decision from the Supreme Court decision over almost a year ago now, but it has these broad implications. And again, where the end result of all of this has just made things more confusing and more work for lawyers, generally speaking, to the detriment of pregnant people and their supporters and to the providers who want to help them. So with that, I'll take a pause, and maybe that leaves us time for some questions.
Thanks so much, Terry. We had so much to cover in this short time, and I really appreciate everybody using their time fully and getting us all this information. Terry, I just had a quick question about LAR. Can any lawyer who's licensed in California volunteer?
Yes. No, we will be happy to embrace anyone who's interested in joining. I mean, I think you need to be from the LAR is essentially a connector. So to the extent that somebody, the way it works is that when we hear about cases, then we go out to the network and ask people if they, put their hands up to take things. And so the lawyer-client relationship then comes between the ultimate client and the lawyer who takes the case. So if your law firm or your practice then becomes the representing party. So essentially, if you're an in-house lawyer, it would probably be harder, or if you weren't practicing, that would be harder because you wouldn't have the infrastructure around to take on the matters.
Okay. Do you have any suggestions for what others can do who are not in a position to volunteer with LAR to help? I mean, there's so many things there's so much to do in this battle.
That is very true. I think the key kinds of things are relate to staying informed and following as much as you can, because it really could be a full-time job, but staying informed about the developments in the space, being involved in the political process, frankly. I mean, this is going to change it may change through the courts. It may more likely, in my personal opinion, change through the legislative process. And I think engagement in that is going to be critical in moving things forward. And with that in mind, supporting and being involved with organizations like Planned Parenthood and the Center for Reproductive Rights and others that are sort of in the mode of lobbying or pushing for new changes in the laws or the regulations is going to be really important too. And to the extent that folks are in a position to donate resources, but to make a donation, all of those organizations are incredibly worthy, and it's going to be a process to get through this. I think I believe we will come out the other side, but it's going to take some doing.
Yeah, I totally agree. And donating to abortion funds or your local abortion fund is always a great thing to do if you have the resources to do so as well. And as Jill mentioned, and I think it's in Terry's resources as well, Jessica Valenti's blog that you can subscribe to is really, really great information that you can get on a daily basis. Because there's just so much going on all the time. It seems a little overwhelming sometimes.
Absolutely.
Yeah.
Pretty much guaranteed to make you mad though every time you read that. There's not
that's
moment.
Right. That's for sure. Well, we only have a few minutes left. I know that we had to give some information about getting MCLE credit. So Alex, do you want to talk about that? So we get that out before we end, and then maybe we can have a question or two if there's time.
Okay, great. I'm happy to do that. So I'm going to go ahead and include in the chat now the link for our attendees to receive their MCLE credit. Go ahead and complete this link. Our board will have receipt of this, and our administrator will help facilitate your access to your MCLE certificates. The code has also been provided in the chat. I am also noting that there is a follow-up email that will be sent out to registered attendees with this link as well as the code. If you, for any reason, are having difficulty with the link, please reach out to the email through the email that you received earlier today with your MCLE materials and the link for this event. And our administrator, Ashley, will be happy to assist you. Otherwise, Andrea, I do not see any additional updates from our attendees. I thought this was absolutely wonderful and I learned so much. So I also want to extend thanks to the panelists for generously offering their time and their wisdom. But I will go ahead and turn it over to you, Andrea.
Yeah, I just wanted to thank you all again as well. I don't know if any of you have any last comments you want to make, or we can just, oh, I see Anne has her hand raised. So yeah, go ahead, Anne. Oh, you can't unmute?
It's the unmuting.
Thank you. I want to suggest two things for people who want to be involved. The first thing is, anytime there is an election, if you have the opportunity to go to a candidates forum, if the person is an incumbent, ask them what they've been doing to protect reproductive rights and trans rights in California. If the person is not an incumbent, ask them what they're going to do. It will inform you, it will inform other people who are at that candidate forum, and maybe it'll light a fire under somebody, who knows. The other thing that I want to urge people is there are a lot of really terrific organizations out there, both advocates, people who are helping, people who need. Don't reinvent the wheel. I get asked constantly, should I start an organization of women who are willing to help other people come from other states. No, there are professionals who are doing this. Here in California, we are incredibly lucky to be the home of Access Reproductive Justice, for example, that does exactly that, that provides practical and technical support for people. They know what they're doing. Don't recreate the wheel. Help the organizations that are out there doing the fantastic work that they've already been doing. They need the help. You can volunteer with them, you can donate to them. It's worth so much more than trying to start something yourself.
Absolutely. And that's one of the reasons why Queen's Bench is hosting these MCLEs, so we can let everybody know about all the wonderful organizations that are out there that they can support, as well as the great things that people are doing, in addition to having to talk about the awful state of our legal justice, social reproductive justice system right now. Does anybody want to, Jill, do you want to make a last comment? We're all good. Well, let me just thank you all again for participating in this. And this event has been recorded, and it will eventually be up on the Queen's Bench YouTube channel. We'll notify everybody of that so that those who couldn't make it today can watch it. And have a nice evening, everybody. Don't forget the Survey Monkey, and you can see the resources on our webpage. Take care, everybody.
Very good.